Good morning, Mr. Gibson.
Good morning, Your Honor. Fellow Justices. Donald Gibson for the appellant, Carolyn Petrell. We come before the court today asking this court to reverse a summary judgment, a portion of a summary judgment that was entered by the Superior Court with respect to what are referred to as the diocesan defendants in this particular case. We think there were at least 5 reasons why this summary judgment, this portion of the summary judgment should be reversed. Number one, it is our position that the First Amendment to the United States Constitution does not shield religious organizations and their supervisory bishops from liability for sexual abuse and sexual exploitation. But
doesn't this concern internal church policies that we're not supposed to get into? Because what you're claiming, your whole claim stems from this bulletin or policies of the church that they put out that's saying that all this shouldn't be done.
I would disagree respectfully, Justice Cowan. The impetus for what the Episcopal Church did was secular in this particular case. It drove, the driving force behind it really was the attitude of the church insurance company in addition to the various committees on sexual exploitation. And what they were seeing in this situation is that their parishioners were being victims of sexual abuse. We're talking about conduct here, not religion.
Just say that again.
I'm sorry.
Just say that again. What did you say?
That what they were looking at is that their various parishioners were being subject to sexual exploitation and sexual abuse.
You mean the church or the insurance companies?
The insurance company, church insurance company, took the position that they were going to segregate and separate their insurance coverage for sexual exploitation and sexual abuse from the general liability portions of the policies that the Episcopal churches were using. And what they said is, if you want us to insure you for sexual abuse and sexual exploitation, we're going to require that you do the following things. And one of it was sexual misconduct awareness training and things of that nature.
Which was done in this case, correct?
Yes. In fact, it's the adult module upon which we rely, in which the committee and the diocese in this particular case, and Elizabeth Bishop, who played a key role here, came to the conclusion that there is a duty not only to act, but there's a duty to prevent misconduct and sexual exploitation, but there is a duty also to intervene when it comes to our attention.
Where does the duty of the defendants here come from?
The diocesan defendants.
The diocesan defendants.
All right, I would.
Where does the duty come from?
All right.
Does it come from their own internal policies, or does it come from someplace else?
I would argue, Your Honor, that it has several sources. First, with respect to their own policies or procedures or protocols, you have before you the history of their sexual misconduct awareness training.
No, I understand that, but it can't be that because institutions, even if they are the employer, which is not the case here, correct?
With respect to Mr. Riccozzi considered himself to be an employee of the parish.
Well, he was an employee of the parish. He was hired by the parish. He was not hired by the diocesan. He was not hired by the bishop. But leaving that aside, even if we were talking about the employer, the fact that an employer has sexual harassment training or takes measures doesn't necessarily turn that into a tort-based duty to any of its employees or anybody that is injured by its employees, correct?
Well, Your Honor, to answer your question, I have to fall back on this court's ruling in Mullins versus Pine Manor College. There, this court recognized that the societal values and society itself evolves to a point. To a point. And that's what's happening, especially here in Massachusetts, with respect to victims of sexual misconduct and sexual exploitation. So
I don't know what the especially in Massachusetts is. We're talking.
You make all these general arguments about victims of sexual abuse, but that doesn't help us decide this case. we've got to decide this case based on whether there's a duty and whether we're interfering with church doctrine.
Is there any evidence that any of these diocesan defendants knew what was going on?
Yes, Your Honor.
There's just that sort of triple hearsay on one of them.
Well, there is evidence in the record that Elizabeth Bishop, who was the one in charge of the or coordinator for the diocesan sexual abuse awareness education, approached Bishop Shaw on September 15th of 2000. She had received information from a lady later identified as Constance Melihoris.
Data identified, but not at the time.
No, but at the time she told Bishop Shaw that Riccozzi was involved with an inappropriate relationship with a parishioner, that the parishioner did not, in her opinion, understand that she was being victimized, and that there was...
She might not have been.
Correct.
There was no indication of who the complainant, who the parishioner was, or at that time, who the person that Ms. Bishop talked to was, right?
She did not divulge, have that information to divulge that information to Bishop Shaw at that particular point. By March 15th, however, of 2001, that was not the case. Bishop Shaw knew it was Carol P. He knew who the priest was. He knew who the parish was. He knew that there were other couples that were involved.
Well, he started...
He did nothing at that time, respectfully, Your Honor.
When was the priest hospitalized?
Not until the suicide attempt by Mr. Riccozzi did not occur until April 26th, 2001.
Other than internal church policy, let's assume for one moment that Bishop Shaw, is it?
Yes, Your Honor.
Might, under internal church doctrine, have had an obligation to do something. Assuming for a moment that was the case, why would that make any difference in this case? Why does that establish a duty owed to this particular plaintiff?
Well,
a tort common law civil duty.
The reason why, Your Honor, in our opinion, goes back again to Mullins versus Pine Manor College. If you assume that this is a voluntary duty that they are implementing or imposing upon themselves, they have a duty to use reasonable care in effectuating it.
But the duty may have the initial. Again, I go back to who was the employer, who was the employee. I mean, this was not the parishioner coming to the bishop, correct?
This was not the parishioner coming to the bishop, but...
If the parishioner had said, I'm coming to you in reliance on this policy, I know about this policy, I'm coming to you, do something.
Right. That sets up a circular argument, though, respectfully, Madam Chief Justice, because these victims, as pointed out by Elizabeth Bishop, don't usually realize that they're being victimized by sexual exploitation.
Was this not an adult married woman? Right?
This was an adult. This was a married woman at the time, yes, Your Honor. But even then, if you look in the record, Elizabeth Bishop acknowledges that she didn't understand that she's being victimized. There is this euphoric sense that they experience, and we would, had we been allowed to go on to trial, would have presented expert testimony in this regard that would have further established that she didn't appreciate what was happening at the time it was happening. So going back to their voluntary assumption of such a duty...
Is it your position that every time any adult person has an affair with an Episcopalian priest, that the bishop owes a duty of care to that person?
Well, first of all, Your Honor, I would not agree that this was a quote-unquote affair, and I think that that's set forth in the documents before the court. I'm saying that...
An extramarital sexual relationship.
I would say that in this particular case, given the duties that were assumed by this particular church, that there was a duty of care. I don't think the court needs to reach beyond that, and I know that we're getting to the Maffei case, but you don't need to reach beyond that. You need to just look and see what this particular defendant or diocese did under the circumstances. I don't think it's necessary to lay down a general rule.
Can I ask you
Unfortunately, when we decide one case, we are laying down a general rule.
You said that's one source of the duty. What are the other sources? So the church's own policies, you say that's a source of the duty. The other sources of the tort civil duty.
The other source, I would simply ask that you take a look at the cases that were decided in the other jurisdiction that were mentioned in our reply brief. Those cases, which come from 14 state courts, several district courts, and the Second and Fifth Circuit Court of Appeals, all have explicitly held that the First Amendment does not bar a parishioner's claim against a church or supervisory church officials related to sexual exploitation.
Did they involve adult?
Some of them did, not all of them, Your Honor.
Did they involve abuse, so alleged abuse when the person was an adult, or alleged abuse that occurred when the person was a minor?
Both, Your Honor.
And which is the case which involves where the abuse was adult? Or if you don't know off the top of your head, that's fine.
All right, I don't have it at the top of my head, Your Honor. It's in, these cases are cited at footnote 1 on pages 3 through 6 of the plaintiff's reply brief.
Even if, if we put Shaw to one side, what's the evidence against Cedarbaum and
Cedarholm, Your Honor.
Cedarholm and the other one?
All right. With respect to Bishop Harris, Bishop Harris was involved in the actual coming of Mr. Riccozzi to Christ Church Parish. She, along with Shaw, participated.
That all went according to internal church procedure and policy, which we surely don't interfere with. This letters dismissory stuff and all that kind of thing. And there was nothing in there that indicated he had this propensity, was there?
There was nothing that we've been able to uncover, Your Honor, that was communicated to Harris. The only other role that she had was she conducted the interview.
There was nothing communicated to her, right?
According to her deposition testimony, she said that there was nothing that was communicated to her. According to the deposition testimony of Mr. Riccozzi, he said that she had before him the Oxford document, the information there about the stalking incident in which he was involved, and she didn't inquire further about it.
He was the victim of that, wasn't he?
He claimed he was, yes, Your Honor.
Well, I mean, he claimed he was. He's a victim. You're hiring somebody. He's been a victim of stalking. I mean, there's...
The case against Harris is non-existent.
Or Cedarholm has had nothing. What's
Well,
Cedarholm?
with respect to Cedarholm, to respond to
Cedarholm,
Justice Greening, Cedarholm was not a bishop until November of 2000. And what happened with respect to Cedarholm is he was charged by Bishop Shaw when the diocese finally decided to do something with conducting the investigation into this and responding to Riccozzi's suicide attempt and speaking with Ms. Petrell.
So this is after it's over?
It's after the relationship has been broken off, yes.
and he
Justice
did that,
Gordon.
didn't he?
Yes, he did. But what happened is he automatically, when he spoke with her, he was going to give a further explanation to the parish as a whole, and that was done in June of 2001. And she was relying, we take the position on him, to accurately tell the parish where liability or where responsibility lay with respect to a situation such as this. And when he got before the parish and did this disclosure, he really didn't do that. He didn't indicate to the parish that she was not at fault with what happened, that the responsibility lies with respect to Riccozzi, and it's persons such as she who are the victims here. And as a result...
I take it a couple things. First of all, her name wasn't mentioned.
It was not.
And Cedarholm was informing the parish that their priest or...
Rector.
Their what?
Rector.
He was the rector? Riccozzi
Yep.
was
Yes,
the
sir.
rector?
Yes.
That the rector had been, what? Removed or suspended or
Right, that he
engaged
had-
in an inappropriate relationship.
With a parishioner. He had been hospitalized. He was no longer going to be allowed to function in the capacity.
What's wrong with that? I'm trying to figure out what's wrong.
There's nothing wrong with that particular part of it, Justice Carter. It's what he didn't say that's important.
Where's his obligation? Where's his obligation to reveal her identity, to identify her as... What's the source of that duty?
All right. The source of that duty, we would argue, Your Honor, is that she was creating, or with him, had a relationship in which was placing trust and confidence that he would accurately explain to
What's
the...
his obligation to do that to that group of parishioners?
I must...
I mean, you're saying that I take it that Bishop Shaw and Bishop Harris and Bishop Cedarholm are being held individually liable?
They are, Your Honor.
So to hold him individually liable, I have to know what the source of his obligation is to give a version to the parishioners with which she wants him to give.
I would fall back again, Your Honor, on the information that's contained in the adult sexual misconduct training module. That's where it came from.
Would I be correct in being concerned that if we agree with you, we would essentially be saying not only to employers, and here the diocesan isn't an employer, but somebody up the chain, do not make the mistake of doing sexual harassment training, do not have any policies, do not adopt any of these policies, because if you do, you will be held liable personally. Would that be a fair conclusion?
I think not, Your Honor, because what we're asking in this particular case, that if you do that, and if you have such policies and procedures and practices, follow them and implement them, which is what they did not do here.
Is there a contract claim here?
No, there is not a contract claim, Your Honor.
Thank you.
And they didn't follow it because between March 15th and April 26th, they didn't, Bishop Shaw
nothing.
didn't act?
They did nothing. He did nothing.
That's the substance of the claim?
Well, with respect to Bishop Shaw, also the information that he had back in September of 2000, that Riccozzi was involved in an inappropriate relationship with a parishioner. He did nothing to investigate that. He didn't talk to Riccozzi. He didn't ask for additional information. He didn't ask that the victim be identified to him. He didn't ask that he could speak with the source of
Excuse me, I thought he asked Bishop to please urge whoever has this information to come forward and speak to him.
That is his version of the events.
I thought that was her version of it.
She said that what he said is, someone will have to come to me directly. That he felt that he was powerless to act unless someone approached him directly.
Well, in any event, we have her testimony as to what was said on that occasion.
Thank you,
you.
Mr. Gibson. Mr. Kinsley?
Thank you, Your Honor. Good morning, Your Honor. Charles Kindrigan, and I represent the Diocese of Massachusetts and Bishops Shaw, Harris, and Cedarholm. This is a case raising the issue of whether or not this particular group of defendants, the so-called diocesan defendants, owe a duty under Massachusetts law to this particular plaintiff who happened to be a parishioner at one of the parishes within the diocese.
Don't you think that the diocese has a duty to supervise its rectors on this subject?
Well, I think there's two tracks here. One is Massachusetts law, which puts a duty upon an employer, but that's not this case. It's undisputed in this summary judgment record that the employer here was Christ Church Parish of Plymouth.
Understood, but obviously the diocese has a lot of responsibility and supervisory control over its rectors. It's the one that can discipline them. It's the one that can take all of these steps to essentially defrock them. I mean, isn't that the case?
That's absolutely the case, but that's the second track, and that is purely of a religious nature. The reason that the diocese has authority is because Mr. Riccozzi has taken vows as a minister to be loyal to his bishop, to follow the guidance of his bishop.
Now,
and it's because the ecclesiastical and canon law gives the bishop certain authority to discipline priests that are within the diocese or to bring ecclesiastical proceedings against them and have a trial.
So only if there is an employer-employee relationship can there be a duty. Is that what
Well,
you're saying?
I'm suggesting that neutral principles of Massachusetts law should be applied to this church, just like any other resident of the Commonwealth. And if you do that and don't get tangled up and entangled within the religious side of this, which is the ecclesiastical law and the canon law.
So if Bishop Shaw was fully aware in September of 2000 that there was this inappropriate sexual relationship ongoing, there was no civil duty to do anything about it. He had no duty to do anything about it under secular law.
Because he's not an employer.
Right.
Yeah.
He had no
yeah,
duty
this
to.
is right. In other words, we're not talking. First of all, we're not talking about something that's criminal or illegal under Massachusetts
That was my
law.
next point. If
But
in
we're
fact it
talking-
were criminal activities, that would create a duty, or how would that be different?
Well, it would create a different dynamic, because to the extent you're talking about religious duties and religious obligations, once you're involving criminal conduct, you have compelling state interests that may outweigh whatever religious rights there are.
That's
But
how you
that's a
would-
different case.
That's
We're
how
not-
you would explain the Catholic pedophile cases.
Well, and plus, in those instances, the diocese was the employer of those priests. I mean, those are cases where an employer is taking an employee who's a known pedophile and moving them from place to place in a position where they can harm more children. That's a very different case than this case. The duty that Justice Cordy was asking about is under Title IV of the canon law of the Episcopal Church that gives the bishop the power to bring proceedings against a priest, in this instance, if he does something that is against the
You're
beliefs
saying
of the
without
church.
canon law, there's nothing that the hierarchy could do here. It's canon law that gives them the
Well,
authority.
The very issues that Justice Cordy raised and that are argued by the appellant are,
If if they all knew from day one, all three of them, that Radowski was a walking womanizer that's going to cause all kinds of affairs, sexual embarrassment, so forth, what you're saying is, it being a civil matter, because no criminal charges or crimes committed, then they proceed against him under canon law, and as to that, the courts abstain.
well, they would say, first of all, when he came to Massachusetts, they could make the canonical decision not to allow his canonical residence to be transferred here so that he'd be eligible for employment in Massachusetts.
That's what Bishop Harris was doing, correct?
Well,
In
Bishop
part.
Shaw is the one who accepted the canonical
No,
residence.
I
Bishop
understand.
Harris happened to meet with him for half an hour
No,
when he
what
came
I'm saying
here.
is, in
but-
part, what you're trying to do is to say, before, it's that, who pays the salary?
Christ Church Parish paid him.
And Christ Church Parish, the vestry of Christ Church Parish raises the money, correct?
Oh, yes. Christ Church hired him. They paid him. He reported to the vestry of Christ Church Parish. He lived in their rectory. They set the number of hours that he worked. They governed his employment, if you will, under the law.
But they couldn't have hired him without the diocese permission.
Well, what the diocese did do, he came from Pittsburgh, and in order to move here and become a priest here, he had to get
The permission
which is
of
this
a
letter
hierarchical-
dimissori.
of a hierarchical organization.
Yes, he had to have canonical residence in Massachusetts before he could be a priest here. So there is this religious procedure that has to happen in order for him to come here. But to get into the question of whether or not there's a duty owed to people on a civil side as a matter of tort law, and whether there can be negligence in the carrying out of a religious duty, is very different than analyzing this case under typical employment
Do
principles.
you even have to get there, because the letters dismissory,
Dimissori. Yes.
dismissory, and all that went with that were entirely in order.
Well, that's true. The Superior Court didn't just analyze this in terms of duty, but went on and said essentially what Justice Marshall said earlier. Even if there's no evidence that any of these defendants had any information to suggest that he was going to
They had
engage
the
in
one
sexual
stalking
misconduct.
thing, and that went in the other direction, that he in fact was a victim of inappropriate action by someone else. Not
That's
that
right.
he was a
Well, that's why
protagonist.
I asked you about the supervisory responsibilities and duties, because I do see that the record has nothing that would suggest negligence, even if there was a duty on the hiring side. But the supervisory side, one certainly could argue that there might be a duty.
But the only power to act, again, would be to defrock him in some way or discipline him under the ecclesiastical
Now, tell
procedures
me-
that are available.
Tell me why the reasoning of the Colorado Supreme Court shouldn't be applied here. In the Moses case, which is a very extensive analysis of almost this exact situation, coming out the other way.
And there are different issues involved in that case. I think what you're getting at is this issue about Bishop Cedarholm and whether the bishop then creates a separate counseling relationship with the
No,
plaintiff?
actually, I'm not getting at the Cedarholm question. Although the Cedarholm question is caught up in this case. Isn't there more in this case?
Well,
than-
Moses found, among other things, that there was a fiduciary relationship that was created with the bishop. But that was based on the fact that this mentally ill woman who the bishop knew had mental issues came to him after the abusive relationship with the priest, and he counseled her in person and
did
convinced
nothing.
her. Well, what he did is he convinced her that he would act for her benefit, and then once having gained her trust and confidence, he said, what you need to do is keep this secret, don't tell anybody. Of course, that's the exact opposite of what happened here. Bishop Cederholm had a couple telephone calls with Miss Petrell. They didn't meet in person other than to shake hands at the back of a church. So in these telephone calls, he explained to her what he was doing, meaning he was investigating this thing that had just come to light. And then rather than convincing her to hide it, he went before the church and he said, he held what he called a disclosure service. He told everybody, this is what has happened, and the Episcopal Church doesn't believe that this is correct, and we're going to do what we can to defrock this man. And so the facts go the exact opposite way than in Moses. I mean, there's no fiduciary relationship is created, and secondly, the bishop doesn't try and hide or do anything inappropriate to Carolyn Petrell.
Was there, Mr. Gibson said that, putting duty aside for a second, that as of March 15th, Bishop Shaw knew who she was and knew a lot more information and did nothing for the next...
Well, I would disagree with some of those facts. You'll have to read the testimony of Betsy Bishop as to what she said to Bishop Shaw. He did not know who she was.
On the March 15th, I certainly...
Betsy Bishop said that she had learned that the woman's name was Carolyn P. She had learned that from the anonymous person. She doesn't say that she gave that information to Bishop Shaw. But again, what Bishop Shaw says to her is, look, I need you to find someone to come forward who's not anonymous and who's not talking through 2 levels of hearsay to tell me about this, because he's looking at Title 4 of the canons, which says that as a bishop, in order to begin ecclesiastical proceedings or to temporarily inhibit this priest, he has to have what amounts to probable cause. He has to have a good basis to go forward, and he didn't deem these anonymous rumors coming to him to be sufficient. I mean, it's different. For example, in the Hiles case that this court decided, there was a complainant, a woman, Linda Hasty, who came forward and talked to Bishop Shaw, and he immediately inhibited the priest and began the ecclesiastical proceedings. That's what he was looking for here. And if you read her testimony, she says, he pleaded with me to go back and find somebody who could come to him and make a statement, somebody who could be a witness, who had either the person involved or maybe this anonymous person who said she believed that something might be happening. Either way, he wanted somebody to come forward, but he couldn't. His view was that under the Title 4 of the canon law, he couldn't go forward and start carrying out ecclesiastical proceedings based on that limited piece of anonymous information. And the real problem here is that essentially what the plaintiff would have the court do is have the Superior Court instruct a jury on what the bishop's requirements are under that title or under that canon law, and then decide whether the bishop interpreted the canon law correctly and whether he applied it in a negligent fashion. That entanglement with the religious law is simply impermissible.
Isn't one of the other problems here is that she didn't come forward as opposed to Hiles. She didn't come forward, and it's very difficult in any organization to operate on anonymous complaints. And she's now saying, well, I'm going to hold them liable because I couldn't come forward because I didn't know that I was being a victim.
Well, that's certainly true. She did not come forward until this whole thing came to light in April of 2001. And that makes it impossible. The bishop's interpretation of the canon law was it made it impossible for him to go forward if she didn't come forward, and certainly if even this anonymous person wasn't willing to come forward and be identified. And again, the anonymous person was saying, I believe there's something going on here. And Bishop Shaw was saying, in essence, that under the canons, he needed more information. But to answer your question, yes. I mean, there is a paradox here that this is all deliberately hidden from the diocese for all this time, and now the claim is, well, the diocese should have been doing something about this. I mean,
That may make a powerful difference if somebody is a child, is a minor. But
well, a minor. I mean, a minor's raised entirely different.
That's what I'm saying.
Questions. Yes, it would certainly make
There's
a
a
different case.
false light claim among the claims, correct?
Well, there was in the appellant's brief. They deliberately waived that claim.
Yeah. Okay.
Yeah. So that's not before this court.
Yeah.
Now, I haven't had a chance to look at these, but in the plaintiff's reply brief, there are 2 pages, single-spaced, of cases that at least has represented, actually almost 3 pages of cases that suggest there is a duty. Are those cases all sort of either because there's an employer-employee relationship or because there's a child at issue, or are they all distinguishable as best you can tell?
All of the above, Your Honor. Yes, there are many of them involve cases of pedophilia, and there are different issues involved there. Many of them involve Roman Catholic churches where the defendant is the employer of a particular priest and is knowingly moving him from place to place or evidence to that effect. There are some cases that, and I think you referred earlier to the Colorado case, Moses, which is certainly a little bit closer to this case, but when you examine the facts closely, is distinguishable on those issues. So, yes, they're all distinguishable. There are lots of cases out there, obviously, on these types of cases, and more than that are in those footnotes. Certainly, if you want to look back at the record and see some of the materials cited at the summary judgment stage to the trial court, you'd see that there are literally hundreds more cases.
Certainly, the law is very clear that at least with respect to employers, the fact that you are a church does not shield you from the normal liability that is, imposed on an employer.
That's absolutely correct, and that's why I said right at the very beginning, I think this is just a case about whether there's a duty under Massachusetts law that's owed. This is not a case where anyone is saying the First Amendment insulates us or gives us a blanket of immunity from tort liability. No one is suggesting that. I mean, if Bishop Shaw got into a car and drove negligently and struck Carolyn Petrell, nobody would be here saying the First Amendment protects him from a negligence claim. The problem is when you try to create a new tort duty or a new tort out of the church's own internal teachings. And that's really the crux of the problem here, is that the appellant is pointing to the church's own beliefs and saying because of your own beliefs, your own religious belief, there's a duty that's placed upon you which is going to be enforced not in the church context but by the Massachusetts courts as a matter of civil law. That, I suggest, is a First Amendment problem.
All right, well, then let's turn to vicarious liability for a second. Let's assume there was a fiduciary relationship between Riccozzi and the plaintiff, counseling relationship of some sort that we would say creates some fiduciary duty. Then why isn't so there is a duty which would be recognized under secular law. So why isn't the diocese vicariously liable? Is it just because they're not technically the employer, even though they had some supervisory control over this?
Well, first of all, as in any traditional case, the wrongdoer, Riccozzi, would have his liability.
Of course. Understood.
The employer, Christ Church Parish, was also sued in this case, and the judge refused to enter summary judgment on their behalf, and there was a settlement of those claims. So the traditional tort defendants have been involved here. This is raising a separate question. This is now raising the question of whether vicarious liability will be extended beyond an employer out to other parties that have a connection and have some power, some authority, but solely as a religious matter.
They have the power to discharge him. They have the power to approve his hiring. So there's not just a teeny bit of power.
Well, but there's a slight distinction. It's not simply the power to discharge him. It's the power to defrock him, to prevent him from acting as a minister. He still has whatever employment or contract rights he may or may not have with Christ Church Parish. So that's why in the record you'll find a resignation as rector that he wrote, and you'll find a separate set of documents that deal with his deposition or defrocking as a priest in the Episcopal Church. Those are two separate matters. There's the civil legal side and there's the religious side. And those are the distinctions. But again, the appellant's sole argument is that you should be able to extend liability to the diocese because of the religious side. And that's where you run into the fundamental problem. So, Your Honors, I would ask that this Court affirm the summary judgment on behalf of the diocesan defendants. Thank you.
Thank you, Mr. Kinskin. We'll take a short break.